All right, I think we're going to go ahead and get started. It's just now 12 o'clock, and I'm going to go ahead and share my presentation with you guys. So let's see here. All right. All right. Welcome to our webinar for the month of May 2026. And today we're going to talk a little bit about milestone planning, estate planning for every milestone. We have all kinds of events that happen in our lives that come up and um, trigger a, do I need to do something with my estate plan? Or do I need to change anything? Or maybe this triggers a, oh my gosh, what should I do next? So I just kind of want to address those different things that come up in our lives and the good and the bad ones that can trigger a time for you to check in and give your estate planning a look. So let's see here. I just want to reiterate some of our practice areas that we have here at Merhab Robinson and Clarkson. Um, we do some estate planning, of course, wills, trusts, powers of attorney, and healthcare directives. And I apologize, I'm still dealing with a wonderful cough from bronchitis these days, but I will do my best to keep that at bay while we talk today. Um, we also do probate and estate administration. So if someone doesn't have a plan in place and we have to go through the court and or potentially non-court ways of going through your administration after someone passes away, we do both of those. We do business succession planning, basically anything for the business owner that they need to keep their corporate books up to date or they're having some employment issues, all kinds of different things, mergers and acquisition, all that kind of stuff, as well as asset protection. Sometimes we have some different assets that could trigger some potential liability or lawsuits in our future. So I want to make sure we can figure out how to best protect those against creditors and litigation. And of course, generally business law, formation, employment, mergers, acquisitions, commercial real estate. Those are all things that we do here at Merhab Robinson and Clarkson. A little bit about me. My name's Cassidy. I think I know at least a few of you that I've seen on there as participants today. I'm one of the senior associates here at Merhab Robinson and Clarkson. I've been here over 2 years now, but I've been practicing for over 10 years. And I love what I do. I specifically really love the planning side of things. I want to help people get their plan in place so that it does what they hope to have accomplished after they're gone or during a period of incapacity. I think it's of paramount importance for us to get our wishes laid out in a legal way so that hopefully they are followed to the best of our trustees and agents' ability, and also to hopefully prevent any fighting or litigation in the future. I'm not much of a fighter for being an attorney. I really don't like to argue. And ideally speaking, we would all have a plan in place that we need. So, what we're going to cover off today is a few different things. Heading off to college, getting married, excuse me, starting or growing your family, whether you're doing that or your kids are doing that, buying a home, inheriting things, starting businesses, all of these different major life events, some of them good, some of them bad. But we want to talk about the details. What does that trigger as far as questions to think about? And what different solutions might there be for you that we could talk about as well? And then approaching retirement. Now what? What do we do? We should maybe look at our plan and kind of check in and see what's going on. And then at the end, of course, I'll open it up for questions if you have a scenario that you want to present or a little thing that you'd like to ask a question about. I won't get into too specifics, but we'll go ahead and go through some of those as well. So feel free to drop those in the chat and I'll try and address them at the end as well. All right. Like I said, life's full of milestones, the good and the bad. And let's talk a little bit about what those might be. All right. Life continues on a forward trajectory. I talk to people every day about death and dying. I talk to people about the positives, getting married, having grandchildren, all of these different kinds of things. And each of these new milestones brings opportunity, but also responsibility to make sure that your estate plan isn't something that you set on a shelf and let get too dusty. I can't say that mine's never been dusty. I definitely did my planning prior to my son being born. And I had in there, this is what happens if I have children. And also what happens if I don't. And that's a great way to start. But also, once you do hit one of those milestones that we're going to talk about today, maybe we look at things a little differently because our perspective may have changed. And we want to make sure that if our perspective has changed, our planning has kept up with that perspective as well. Okay. Um, Very commonly, I have people come in for their 3-year review meetings with us where they come in and they sit down and they're dusting off the top of that binder. And that's fine and that's good. I've been there too, where life gets busy, it gets away from us, and we maybe haven't really been checking in on our estate planning as much as we should. Okay. Hmm. Outdated plans can create unintended consequences. I'll talk a little bit more about this later, but I specifically down with someone today and their spouse had passed away. And we were talking a little bit about some of the different things that he's been going through that maybe he didn't anticipate having to deal with after his wife passed. And some of those things include some rather urgent planning that they did a very long time ago before they were traveling, and he had entirely forgotten about a potential life insurance policy that they had set up many, many years ago, like 40 years ago. And they had never updated the beneficiary to be appropriately named. And now he's going through one, having to deal with that financial institution to try and figure out what is the value because he has no idea. And two, is it going to be a probate issue? Are they going to have to go through probate court? Is it a low enough value that we could do something alternative to that outside of the court system? But it's just one of those things that keeping on top of those different documents can prevent problems and unintended consequences going forward. And I'll keep giving those little tidbits of information and different examples along the way. Like I said, potential problems ending up in probate court. Probate's like my least favorite thing. I probably wouldn't wish it on my worst enemy. I do probate court on a regular basis as well. We appear luckily now by Zoom, which is kind of fun. Although I did have the power go out in our building the one day that that was going on recently. So that was a very interesting little hiccup in the plan. But the probate court is a very unique beast in that it is a 12 to 18-month process that your assets might have to go through if you don't have the proper beneficiaries named or if they're not titled in your trust properly, different things like that. And it is very costly. It costs about 5% of your assets to go through that. And then ultimately, it could end up disrupting a beneficiary's benefits. Recently, I was going through a trust administration with a family that they never updated their plan after their child was determined to be eligible for Medi-Cal and some other government benefits that only allow them to have about $2,000 in their bank account. And while the child doesn't get that much money from their Social Security disability income that they receive, the concern isn't really that, it's the medical care that they receive otherwise. My mom is a special needs beneficiary. I use her as an example regularly with our clients. She later on in life lost her vision and became a disabled individual. And she also has that income and asset threshold. And so it doesn't sound like that big a deal, $600 a month that someone would get. But also, she's had brain surgery, she's had multiple heart surgeries, she's been in the neurocritical care unit at UCI Medical Center. All of these different things are covered by her Medi-Cal benefits. And if we didn't have the proper planning in place and she were to inherit, say, $50,000, her medical care could be disrupted during that period of time. There could be a reapplication process for those benefits. And having been with her while she applied for her Social Security disability benefits in the first place, I can tell you they very commonly deny someone's eligibility in the first place. And I can't imagine having to go through that application process again. Excuse me. And then also potentially having to appeal that decision like we did in the first place. So those are different things to consider in disrupting a beneficiary's governmental benefits. A waste of trust assets. Sometimes when we end up going through probate court or dealing with these small estate affidavits or different things to gather and marshal these assets for an administration, we're wasting time and money, whether it's legal fees or just the duration of time to acquire those assets back to the trust and the estate. We could miss a window where the property would have sold for a substantially higher value because we're busy getting title appropriately handled to get through the administration itself. So all of those different things can waste time and money through the administration. And then also failing to provide for someone you love. A lot of people, their trusts go on to their children if they have any. If they don't, it would go on to grandchildren maybe. But if you don't have grandchildren or if you don't have children, one, you get to decide who, if anyone, specifically gets your estate, whether that's charity or individuals, and that's great. But what if that organization that you provided for has changed, or your heart and your desires about those different kinds of organizations has changed as well? Sure. Those different things are reasons to call up that estate plan and just say, maybe we should adjust. Or, wow, I love my grandchildren so much. I want each of them to have a little something in memoriam from me that they could use to take a small trip while they're young or get them into the real estate market or something like that without having to wait for the money to pass through their parents to get to them eventually. So those different kinds of things are ways that we want to make sure that we've updated to encompass those wishes so that you don't fail to provide for someone that you love, or maybe even a new love in your life. Who knows? All right. And then also providing for a beneficiary that you do not want to receive. This comes up more often than not, that someone in your life changes in a way that we wouldn't want them to receive. And that isn't always a bad thing. It's not even their fault a lot of the time, but we'll have issues with addiction or disability or different things like that that you would want to change the way that they receive, or who would be in charge of managing that beneficiary share, just to adjust for different changes in their lives as well. So it's always a reason to check in and see if there's adjustments that need to be made. All right. Looking at the wonderful world of probate, like I said, I don't wish it on my worst enemy. It's not my favorite thing to do. Um, there's a fee schedule related to probate, and I say it's expensive. I'm not kidding. It's it could take about 5% of the assets of the value of the estate to go through probate. And if we're looking at a $1.3 million probate estate, we're looking at approximately $52,000 just in attorney's fees and administrator fees. And what that doesn't show is the time or the emotional toll that it takes to go through that process. When it comes to grief, of course, it's a wild ride of waves of emotion, whether that's anger or denial or frustration, just different things that we go through in order to grieve the loss of a loved one. When you're going through probate and dealing with all of the different logistics associated with that, sometimes we don't have the opportunity to work our way through those different stages of grief. And that's probably the hardest part of walking through this process with our clients is knowing that we're checking the boxes and we're doing the things necessary to get through probate, but we're maybe really not getting to the root of the emotion behind it, the frustration behind it, and the sadness of losing a loved one because we're so busy dealing with the court process to get through it. So just know that while there's a financial cost that is significantly more than the planning that it would take to avoid that, there is also an emotional toll that it takes on your family as well. So just something to consider when thinking about doing your planning and making sure it's up to date. All right, let's talk about something positive for a second, because one of the beautiful milestones that we have in life is when your children head off to college. Now, my son's 4.5, so not quite there yet. We're heading off to pre-K next year, but heading off to college is a big milestone. And that milestone comes up with some responsibilities as an adult. So I put a scenario at the top here. Your son Evan goes off to college to study at Arizona State University, and it's a wonderful thing. You're so excited for him. But you get a phone call from Evan's friends that there was an accident. They don't know what hospital he went to. They don't even know if he's okay. And you begin the agonizing task of calling the local hospitals near the university to hope that someone will give you information. Okay. HIPAA is a beautiful thing in some ways and also a very frustrating thing in many ways. Now that your child has turned 18, they have privacy rights relating to their medical care under HIPAA. And From what I understand, there's also certain privacy rights even younger through different health organizations like Kaiser. I think it's under the age of or over the age of 14 or so that they'll stop sharing reproductive information with parents for 13 and 14-year-old young individuals. And it's just a very complex area of law. And if your child decides they don't want to share this information with you, they can. And so the question is someone going to tell you if your child's okay? You hope that you get that person on the phone at a hospital that has a heart and some compassion for what you're going through. But legally speaking, they can get fined and in trouble for divulging a patient's information to someone without a HIPAA authorization. Will they tell you that that hospital is giving care to your child? Maybe not. And you might be stuck trying to figure out where to go and who to talk to. Eventually, you hope that they figure out that you are next of kin and should be contacted, but without the proper documents in place, I don't know that they would. And I have seen this happen where people are in a panic trying to find out what's going on with their child with limited to no information. So, what's the solution? Now that your child is 18, they need to have an advanced healthcare directive, a HIPAA authorization, and a durable power of attorney at minimum. If we're talking that they also have personal assets, even a little bit of money, they probably should have a will as well that directs what would happen with those assets should something happen to them. You know, these things are all part of becoming an adult and accepting the responsibility of your finances and your personal care and things like that. Mom and dad aren't always going to be there to make their medical decisions for them, but in the moment that we can't make them for ourselves, we want to appoint someone to do that for us that we trust and we think would do so based on what we want for ourselves. Okay. All right. So we call this a foundational plan at our office. It's very common for our 18-year-olds to come in and sign documents with me. I think I had a really rough realization recently that I was probably old enough now to be their parents, and that was unfortunate. So we definitely work with the 18-year-olds to get these documents done. And I've never had any issue with them being done in California and them going off to college in another state or anything like that. So it's definitely something that we can do as they technically are residents of the state of California, even if they go off to school in another state. Okay. All right, let's see what next milestone we might come up on. Oh, someone's getting married. Yay, right? Happy things. Okay. So we've got a few happy ones in here. That's good. I've got a few sad ones too. All right, your kids are grown. They're off living their own lives with the families they've built. Um, and you are now getting married. We've got a second love in our life. And all the planning events and celebrations, updating your estate plan is probably one of the last things you've thought about, but it probably should be one of the first things you think about. Um, the reality is that if we don't update our estate plan, if we get married, there are different things that can happen in the probate court that could cause problems for both your children and your spouse without having updated your plan. So there's a few questions we need to ask and something that we need to address. And ideally speaking, I always tell people if you're thinking about doing something that could affect your estate planning, whether it's dealing with your assets or people or signing a marriage license that then legally obligates you to another person and creates property rights and things like that, you should talk to us before you do it because it's hard to unravel what you've already done and it's better to plan for things that you want to do in the future. So, do you want to provide for your new spouse? Good question. How do you feel about that? Have you known them your whole life and this was just the reconnection that you've always needed? And yes, of course, you would want to provide them. Or did you build a beautiful legacy of assets and a business with your spouse that has passed away and you want to protect that for your children? I can understand that too. Those are different things to consider. If you pass away, how is your spouse going to provide for themselves? Are they going to have enough? Have they sold their house and things and invested in your properties to be able to do those different kinds of things? And will your children and your spouse fight about what is supposed to happen or what they feel they're entitled to? One of the worst parts of doing our jobs is the side of administration that can get ugly, whether or not someone holds out their hand waiting for what they feel they're entitled to, or someone feels that someone took something that they weren't entitled to as well, you know? So when I say planning is easier on the front end, I'm talking about things like, okay, we're talking about getting married, we're in love, we've got the ring, we're doing all the things. Have we talked about a prenuptial agreement? Do we both have assets that we would want to protect and keep safe for our children should something happen as far as a divorce in our future? The divorce rate is over 50% in our country. And that's not to say that any of us enter into marriage with the intention of divorce, but things happen. There are certain things that would trigger me to go down that path, and I hope they never do happen to me. But I would rather make sure that my family is protected with the proper legal documents than go back later and think, gosh, I should have done something when I got started. And then the other part of that is update your estate plan when you get married. Who is it? When did you get married? Are you providing for that person? Even if you're providing for that person outside of your estate plan through beneficiaries on whether it's a specific account or retirement or life insurance, different things like that, that's all something that should be addressed as part of the conversation after you get married. All right. Your child's getting married. This is a good one too. All right. Your son's grown up and is marrying the love of his life. Yay. You're so excited. Can't wait to add a daughter to your family. They want to have children quickly and you're excited to be grandparents. These are all wonderful, beautiful things coming forward. Okay. So now here's kind of the more practical, realistic side of things. All right. How did you provide for your son within your estate plan? Will his assets be protected when he inherits? Should he go through something like a lawsuit or divorce or different things like that? Did you plan in a way that considers potential grandchildren? Would you want to be that grandma that leaves something in memoriam for your grandchildren? Or now that you're at the point of having grandchildren, do you want to make sure that you pass down certain heirlooms or personal property to them that you hadn't accounted for before? Okay. Do you feel like your son, if he's acting as your trustee or your healthcare agent, can do so without a strong influence and pull by his new spouse? Those are all things to consider and questions that we need to start asking and thinking about as these different things occur in our family. So, what's the solution? Of course, review your estate plan. We always are trying to reach out to you guys about every 3 years. I mean, we do it in mass to where we send out a bunch of letters at the same time to say, hey, it's been a while since we've seen you. Is it time to address your estate plan? Has anything changed with you? Family dynamics, additional family members, divorce, different things like that. All of those different things are part of why we should address this. And then you need to see, does your plan address the way you want it to? Maybe it does. When we talk to people, I always tell them it's like drinking through a fire hose. Some of it sticks and some of it goes right on past. But hopefully, we can refresh your memory about what your plan does and then address what the changes should be if you want to see something different. So, might be a good time to call us and just have a quick chat to see if things do what you want. All right, one of the not so happy milestones. You're getting divorced. All right, I didn't put a scenario here because I think that one kind of speaks for itself. Unfortunately, some things don't work out. So, when getting divorced, there's a few different things that we need to take into consideration. Does your plan still work if you get divorced? Very commonly, upon the filing of divorce, a joint estate plan, a joint trust, no longer works. It treats you both as though you predeceased the other. What that looks like is you wind up in a problem because now you've got a plan that doesn't work the way that you want it to. Very commonly with our married couples, we also have that we've appointed our spouse to be our everything, our trustee, our healthcare agent, our power of attorney, and some of those documents are effective immediately. So we might want to update those because maybe you don't want that spouse that you've just started to get divorced from being the one to make the decision about whether or not to pull the plug. And I know this is a somber conversation, but it's a very real conversation that that person, if still named in your power of attorney or your healthcare directive, could be the one that is supposed to make those decisions for you. And maybe we should update that. The other thing I always caution people with is when we have joint clients, we represent both of you. So what that means is I can't keep secrets from the other person. And I always tell people, don't tell me anything you don't want the other person to know. That's a big one. But also, if something were to happen in your marriage and you're filing for legal separation or divorce, I would need the other party's permission to continue working with you. So, if your spouse decides, nope, I don't want them to continue on with your office, they could not give us permission and you would have to go on to another estate planning attorney. Happy to provide you a name or a referral or point you in the right direction, but just know that there are circumstances in which we could not continue to work with you because we've worked and represented both of you. So just know that that could be an issue. The other thing is, do you have a joint plan or do you have an individual plan? I have plenty of couples that each have their own individual trust. They have their own stuff and we plan for it separately. No problem. Great. We can update your planning separate from their planning. No big deal. We keep it all separate, right? But it is a good time to then update and check in on your estate planning documents. Again, that is a big life event. So we want to make sure whether or not we can work with you. Is your spouse okay with that? Have you filed for divorce yet? There are some family law considerations when filing for divorce. If you file for legal separation or divorce, there are what we call ATROs, ATROS, and they're temporary restraining orders that basically make you keep the status quo as to titling of your assets. So you can't then move around money, change names on different assets, different things like that. So you want to be mindful of that when it comes to doing your estate planning. And it might be a conversation to have with your family law and estate planning attorneys as to whether or not you should update any planning or asset information prior to filing for divorce. Okay? Worth a conversation to see what you should do going forward. All right, let's go back to a happy one. You're having a baby. Yay! That's exciting. These are my favorite ones. I love to talk to our young clients about starting their family and putting together the nursery and doing all the fun things associated with having a baby. And you know, mapping the route to the hospital and packing your hospital bag are very important things, but so is your estate plan. So, like I said, when I got started, I went ahead and did my estate plan in a way that provided for my children if I had any, even though I didn't at the time. And then it would also provide for if I didn't. But I will say that very commonly people don't provide for future children in their estate plans. So it might be something we need to address. If our young individuals have gotten their estate plan done early on, they may have provided that things go back to siblings or parents, different things like that, rather than to their children. Married or not, you might want things to go on to your children. All right. And if you're pregnant, does your healthcare directive address what happens if during your pregnancy there is an issue? Have you addressed whether or not you would want them to do everything at all costs to save the baby, your life, how you would want things done? Those are all very important conversations to have, and also to make sure that your healthcare directive addresses those issues as well. So, those are very, very important things. Unfortunately, we have not gotten to a point where maternal mortality is zero, which I wish it was. And unfortunately, we do see circumstances where women in labor and delivering children or even in postpartum have passed away. And we've had to deal with these issues with their healthcare directives and things like that. Okay. So again, setting up the nursery, painting, putting up the wallpaper, mapping to the hospital, all of those are important things. But we also want to make sure that our trust and our will and different things like that are incorporating how we would want to provide for our children. And then also, after your child's born, you don't necessarily have to, if we've already planned for our future children within our estate plan, update things. But I would say 9 times out of 10, mom and dad want to see their kid's name in print. So we see our families come back in to reference baby's name, date of birth, and put their name in the documents to show how they would be provided for. And then the other thing is we want to make sure that we do guardianship nominations. Unfortunately, the reality is if you don't do a guardianship nomination and something happens to you and your spouse or both parents of a child, um, The court will appoint someone to be the guardian of your child that they think is in the best interest of the child. What does that mean? Well, on paper, it might look like a married woman with two children of her own that's a stay-at-home mom and um, has sufficient assets of her own to care for her children. And she's your sister-in-law and she raises her own kids, and on paper looks like a great option. And it might not look like your baby sister who's 22 and just finishing college and lives in an apartment that doesn't have a whole lot of assets. But when it comes down to it and you think about who would raise your children in the way that you would want them to be raised, it would absolutely be your baby sister all day long, and it would never be your sister-in-law. And so, unless you put that in writing for the courts to weigh and determine what would be your wishes and in the best interest of your children based on that, the court might decide to put someone as the guardian of your children that you would never want to be that person. So, just something to consider that the best interest of the child in your heart might be different than what the court sees on paper. So, it's definitely worth it to document who that is. All right. Got a baby, got a house. Yay, exciting things. You took the big step of buying a house. Now what? All right. How'd you hold title? Are you married? Do you own it with your spouse? Do you own it as tenants in common, joint tenants, community property? There's all kinds of different ways to hold title to real property. And each of those comes with its own pros and cons. If you own it as your sole and separate property, even though you're married, great. If you got divorced, then maybe it's still yours. Hopefully you haven't commingled things too much. But if you pass away and you own a property in your name alone and it's not in a trust, we might end up in probate court again. And I know that there are some new laws that have come down that allow you for the transfer of your residence, if it's under $750,000, to come through a shortened procedure in the probate court. But anyone that lives in Orange County knows it's a rarity to have anything under $750,000 for one. And two, would your spouse then have a claim to it as well? And is that what you would have wanted? So, acquiring a house comes with it, again, additional responsibilities. Even if it's taxes and insurance and different things like that, that's part of it. But also, we want to make sure that if something happens to us, would we want our spouse to be able to live there? Potentially, especially if they're going to be living there with our children and being able to provide a stable home for them, continuing at their schools and things like that. So, those are all things to consider. Um, Your home, like I said, if it's under 750,000, we can do a shortened procedure. So we probably wouldn't end up with the probate issue referenced here that's $208,850. So if we're in that kind of flux in there, that's fine. But the likelihood is if you're owning home in Southern California, it's probably worth more than $750,000. So we need to make sure that we're planning appropriately for your real property. And ideally speaking, when you're looking at buying a house, you let us know. Why? Because we can do things to show you how to purchase that property in the name of your trust. And then you don't have to come to us later and have us do a deed. We're going to save you time and money to make sure that you can do it by yourself ahead of time and do it the right way. The other thing to consider about buying a house is changes in the law. So for many, many years, there was something called Prop 13. Prop 13's changed recently. In 2020, of all things, we got something new, not just COVID. We got Prop 19 as well, and that changed things. Unfortunately, I think what happened with Prop 19 is that the legislature and those that were lobbying for the changes to come through in Prop 19 hid some bad things in with a good part of the bill. So we have these really significant good things that happened for seniors, wildfire victims, and disabled veterans and things like that, where they can now move their property tax basis all around to most counties in the state of California. That's phenomenal because it used to be that you could only move it around in your same county, and that was hard for people. So they put that in there, and then they added to it a section that allows for you to pass your real property to your children, so long as it's your residence and it becomes their residence, and exempt some of that from a property tax reassessment, some of that. It's basically the assessed value at your date of death plus $1 million. So say it was a $300,000 assessed value at your date of death, and now the property is worth 1.5. So we've got that 300,000 plus a million, 1.3 is protected from reassessment, but 200,000 of that property will still get reassessed to the current fair market value for property tax purposes. So it's going to go up a bit, but not nearly as much if the full property was reassessed. What that also did is it took away the parent to child exclusion for rental properties and commercial properties and things like that, that otherwise used to just parent to child exclusion all the way down and continue without triggering property tax reassessment. So, unfortunately, the property tax change could trigger an instance where your children then cannot afford to retain property that you're going to leave behind for them. So just know that going into this, that when you want to leave behind real property for your family, there may come a circumstance in which it is not feasible for your family to hang on to that real property in the state of California. Now, this is something that went through the legislature and it is a law that can be changed, but so far we have not seen it come back onto the ballot. So, as of right now, that is the law, and that's what we're seeing happen going forward. So, just be mindful of that when you're leaving real property behind for your children. All right. The next common call I get is, we sold our house. Now what? What do I need to do? Nothing really. I mean, you sold your house. Okay. It's no longer a part of your trust. That's fine. It just means it's no longer governed by the terms within your trust. So when does that become something that makes you need to update your estate plan? Well, it could be that you provided for a specific gift of your property, and we can look and see if the terms provide for what happens if that property is sold, if there's a replacement property. We may have put something in there to that effect. If we didn't, and you just don't care, like it just says that if we don't own this property, it goes away, we don't have to update it. It just means you don't own it anymore, that gift goes away. But if you now want to say, okay, I've now purchased this other property and I would want that property to go to this family member instead, then all right, we should probably address that. Okay. And we might need to make an update there. Um, and then what do you want to happen with this property? If we didn't plan for it before, do we want to add something in there now? Maybe this property is something you bought because it's close to your daughter and her children, and you are going to have them live with you to help care for you, but ultimately you would want it to go to your daughter. We should probably address that in your estate plan as well. And then I also want to know, how are you holding title on this property? Okay. When you want to make sure you sold it, okay, it's no longer part of your trust, gone, fine. But did you do something wonky and it's still in your trust? It's just something, titling is the most important part of all of this. Titling is what controls when it comes down to it. Having a house listed on your schedule of assets in your trust doesn't control who or what owns the property. So just because it's on your schedule doesn't mean it's in there. So we want to make sure that the ownership is what controls. So again, if you sold it and it's gone, it's in somebody else's name, we don't have to worry about it really. Okay. All right. Next thing's next. All right. You started a business. Yay. All right. This one hits close to home. I'm not going anywhere. I'm not starting my own business, but basically your career as an attorney took off. You thought you'd have some more flexibility if you opened your own law firm, and you and your best friend from law school are going to start a partnership. Congratulations. All right. Did you create a business entity? You guys just hanging a shingle and hoping it works the way it should? As an attorney, I would hope that people didn't do it that way, but I can't say that I haven't seen it done before. So, what I would say is that, did you create a business entity? Okay. What does that mean? Did you start an LLC? Do you have a sole proprietorship? Do you want to incorporate? All of these things are to take into consideration when you're starting a business. Um, are you the owner? Are you and your business partner owners? Who owns more? Who has the ability to buy the other out? Can you transfer your interests? These are all parts of creating a business. We have a business department here that advises on that kind of thing. But these are all things that come up in your estate plan too. And if something happens to you, who do you want to receive your interest in the business? Would you just want your partner to continue on and run the business and then your family to never see the fruits of that labor that you've put into creating this business? I doubt it. So, what should we do when we're starting a business? One, consult with an attorney. I know it's expensive and it costs money to do so, but in the long run, that investment in the advice um, is worth it because ultimately you could cause yourself more time and money later on if we don't get the right advice and counsel in the beginning. Okay. Very commonly, when we start a business, we do open ourselves up to new streams of liability, whether that's as an attorney, someone filing a claim against the business, or as a doctor suing because of a medical malpractice issue, different things like that. So maybe there's something we should do in forming a business that provides us some liability protection. Is that business walled off or protected from our residents? Or could that person that sues our business now come after our house that our family lives in? I want to take into consideration those different things when it comes to starting a business. Okay. And when we do form a business, there's different things that we need to be mindful of, like can you transfer your interest without asking your partner? Very commonly, the answer there is no, because does your partner want to be in business with your wife? Probably not. They want to be in business with you. So if you're ever going to transfer your interest, what are the restrictions on that? It probably says within those governing documents. Okay. And then are you able to fund your business to your trust? Are you able to assign your interest or reissue your corporate stock to you as trustee of your trust? These are things that we need to look at rather than just list your business on the schedule for your trust. That's not sufficient in what we're doing. Okay. When talking about a business that's a professional practice, I'm talking about a business in which you have to have a certain professional license to operate that business, whether that's a lawyer or a doctor. Those are businesses that can't be owned by people that are not lawyers or doctors. So we can't have a layperson that is a partner in a law firm. There's restrictions against that. Okay. So have we provided for a trustee that has the proper license to be able to sell or liquidate your business should something happen to you? These are things that we need to address in your estate plan. So if you didn't have a professional practice before and you're creating one now, we need to look and see if the appropriate provisions are within your estate plan to do so. Okay. All right. Oh boy, this is a big one that's come up a lot. And you know, there's been or was a mass exodus out of the state of California for many different reasons. And one of the things is people have moved off to Texas, to Tennessee, all kinds of different places, and good on them for getting to where they want to be in their life and the location they want to live in. Okay. So, does your estate plan work? Maybe. It depends, is the best lawyer answer we've got. No, um, I say that kidding because that is totally the lawyer answer. Well, we don't practice in other states. We practice in the state of California, and all of your documents were drafted based on California law. So, things we need to consider are that the laws in another state may be different than the state of California. So, will there be a probate issue in Tennessee if you've moved to Tennessee? I don't know the answer to that. And the reality is that you should check in with a local estate planning attorney in the state you're moving to and changing your residency to so that you can address whether or not your planning does what you need it to do in their state. Okay. HIPAA is a federal law, so I don't see a lot of problems with HIPAA authorizations or healthcare directives in other places, but it might not be exactly the format that that state is used to seeing, and it might be worth updating in your new state. Okay. So, something to consider, something not too fun to deal with, but as part of moving and changing your residency, you should update your estate plan as well, or at least check in to make sure it does what you want it to. Okay. Um, let's see what else we've got here. All right, this is a good one. And my final real big happy one is you're inheriting money. And I say that kind of facetiously because my biggest pet peeve about trust administration is that people think that they should receive something or benefit or profit when someone passes away. And it really honestly breaks my heart. And maybe I'm just an old sap or a, a bleeding heart or whatever you want to call it. But I have a really hard time with the fact that someone has passed away and someone thinks that they should receive something because realistically speaking, they've lost a person. And I just view that as an entire loss. It's not about receiving anything in that moment, and I wish I could help people to understand that. But the reality is that you lost a person. And if you gain anything from that, um, it's a minor consolation to what you've lost. So the scenario here is your great Aunt Louise passed away and you're named as a beneficiary in her trust. Okay, so what do we talk about then? Do we know if you're receiving it outright in trust or in trust? Okay. What does that mean? Outright means it's yours. You get a check. Here's your share. Do as you please with it. All right. Sounds great. Wonderful, right? You go ahead and put that in your bank account that's in your trust. You move about your business. Potentially. Did you know that your inheritance is considered your separate property in the state of California, even though we live in a community property state? Anything that is received by gift, inheritance, bequest, or devise, all of those meaning coming to you as some sort of gift, whether in life or in death, is your separate property, unless we commingle it, meaning we mix it all up with something that's community property. And that's very easy to do and something that we need to be mindful of if we would want to protect that as a separate property asset. Do you know what the value of what you're to receive is worth? Okay. Is it a house worth $1 million? Is it $20,000 as an in memoriam thank you for being my grandchild? Different things like that create different considerations and maybe trigger a different kind of planning or action that you may want to take. So, something to consider, is it a huge value? Is it a smaller thing that you would just want to take your family on a wonderful vacation and then that inheritance will be expended? Okay. So, what's the solution here? You want to understand how the assets are being distributed to you. It can affect your control. It can affect your protection from creditors and liability, and it can also affect how you plan for what happens with that asset should something happen to you. It might be already dictated within Aunt Louise's plan what happens to the assets remaining after you're gone, or it might allow you to plan for those assets if something happens to you in the future. So that's about understanding how the assets are distributed. Different kinds of assets, cash, real estate, retirement accounts, business interests, they might come with different rules and responsibilities. Real estate, are you receiving it subject to a mortgage? Are you now responsible for the mortgage, taxes, and insurance on that property? Or are there assets being left behind to cover those things? Are you being given the right to reside in the property, or are you given the asset in its entirety? Those are different things and might come with different responsibilities. Cash, well, maybe not a whole lot of responsibility with cash, but being responsible is always good too. Retirement accounts. There are laws surrounding the distribution of retirement accounts and how long you have to withdraw those assets. That's important. So, you want to make sure that you have conversations with financial advisors, CPA, attorneys about how you can withdraw those assets, what will provide you the best tax benefit, and potentially how long you want to take to withdraw those funds. Okay. The value of the inherited assets can impact your investment decisions. If we have $20,000, we might behave differently than if we have $1 million. Okay. It could affect how we plan for taxes, our retirement goals, and how we handle our assets going forward. Those are all kinds of different considerations that we may want to take into account when we're doing our estate planning after we've inherited some assets. So it's always a good time to check in and see, maybe we want to set up a separate property trust to just carve out a special box and place for these assets to protect them Should something happen to us, whether it be a divorce or death, would we want these assets to transfer directly to our children upon our demise? Some assets have restrictions that they have to stay in the familial bloodline for your heirs instead of your spouse. So these are all things we need to look at when we're inheriting property. Okay. All right, so we've kind of touched on a lot of different milestones here. We're getting towards the end of our presentation. And the next thing I just want to address is some common estate planning mistakes that we see. Not updating your documents after marriage, divorce, birth, death, anything like that, whether that's an agent you've named as your trustee, your power of attorney, your healthcare agent, or a beneficiary. Like I said, this morning I was having this conversation with someone whose spouse has passed away, and 40 years ago they set up a life insurance plan, and the beneficiary on that plan is someone that's no longer the trustee of their trust, and it was done in a way that maybe 40 years ago was accurate, but it's not how we do it now. And we might run into a probate issue. It's hopefully resolvable with some paperwork, but I'm not sure at this point because we don't know what the value of the asset is. And then there's changes in the behavior and the responsibility of our beneficiaries. I have an administration currently that there was a beneficiary that became addicted to drugs and alcohol and became a person that was not someone to be trusted with assets. And that's an unfortunate, very sad scenario for this family. But in order to protect that beneficiary and the legacy and funds that they had built in their lifetime, they went forward and disinherited that person, but they forgot to update their retirement accounts. And now this beneficiary is coming into over $500,000 that could potentially be used to buy drugs and kill them. And these are horrible things that we have to talk about that are so important that we need to address in your estate planning. Okay. Failing to coordinate beneficiary designations, IRAs, life insurance, that's what I was talking about with that failure to change that retirement account. And then assuming your estate plan is or your estate is too small to benefit from a trust. Estate planning to me is a misnomer. All of us have an estate. It's our person, it's our legacy, it's our wishes, it's our dreams, it's our assets, it's all of those things are part of our estate. But the trigger for probate is only $208,850. I'm sorry, that needs to be adjusted for inflation. And that's a very small amount when we add up this account and this little thing to get to that number. And we could end up in a 12 to 18 month process. We're seeing filing of documents taking 8 weeks to process in the County of Orange right now. That's just to process and receive it. And then they're setting hearing dates up to 4 to 6 months out. I have hearings that are set for August when we filed the petition in January. These are things that cause delay and stress and turmoil for your families after you're gone. So they're things that we don't want to go through as our families are grieving our loss. Okay, so why does estate planning matter? I think we've kind of beat that horse, but without a plan, California law decides who speaks for you and how your assets are distributed, and it may not reflect what you want. Probate is a very public, slow, and expensive process. I don't wish it on my worst enemy, and I don't wish for you or your family to have to go through that process. So I want to be mindful of that. When we file a will in the state of California through a probate, those petitions are public record. There's some things that are filed confidentially, but not a lot of them. Those are all part of the public record. The value of your estate is on the front of that petition. The address of your beneficiaries or your heirs is on the proofs of service and different things within those documents. Your family will start to get harassed by real estate agents, predators, different things like that that we do not want them to have to deal with as they're grieving your loss. So just be mindful that a complete plan protects your family, not only from court proceedings, but stress and delay and things like that. So working with a qualified estate planning attorney to address your needs for your estate plan and fits your situation is so important. All right, so questions. Feel free to drop things in the webinar chat. I'm going to stop sharing my screen here so that you guys can see me as a bigger person here. But questions, I'm happy to answer them. As a reminder, anyone that's been registered for this presentation, we will be sending out the recording. We always record these, and you guys will get an email from us with the recording and information within the presentation. So I'm happy to address any other scenarios that you've come up with or questions along the way. And if you need a 3-year review or anything like that, just as a reminder, if it's been a while since we've seen you, that first half hour is free of charge, where we just go through and talk about what your estate planning does. And only at the point that you want us to draft new documents or do any additional work would I quote you an additional fee. Or if you want to sit for longer and talk about different changes and things in your life, then we can bill hourly for that meeting if you don't want us to make any updates to your documents. So that's just something that we can do for you as well. Let's see what kind of questions we've got coming up here. All right. So, all right. So I think this one is coming up. All right. So you have an 18-year-old and they have documents, but they've gone away to school in Massachusetts. Is that a problem? Okay. So as I mentioned, very commonly we do documents for kids that are going off to college in another state. And we've not run into issues where all of a sudden there's there's a residency issue or anything like that, that a hospital or anyone like that wouldn't accept those documents. I've never had that experience. I've been in practice for almost 12 years now. I don't know that anyone in my office has ever mentioned issue there, but I would say if they determine that they're going to establish residency there and maintain residency in another state, that might be a time for them to update their planning in that state. But if their intention is to return home, I wouldn't feel like you needed to update those documents. Realistically speaking, our 18-year-olds get their estate plans or their foundational plans done with us commonly and then don't update them again until they're getting married or they're having children, different things like that. Those are usually big triggers for when people update their estate plans. Another time that people update their estate plans with us is after their kids become adults. Because we plan when they're young, we do guardianship nominations and things like that, but they're not old enough to make decisions. And so we have other people in place to be those decision makers for us. And so then when their kids have become financially responsible and maybe someone that they could trust to make those end of life decisions and financial decisions for us, that's when we would update again. So very commonly that dusty period of when your estate plan sits on the shelf is when your kids are young and you've got your estate plan in place. But I would say the most common thing that people update is their guardianship nominations as well. So, all right. Looks like I don't have any other questions at this point. So unless you guys have any for me, we can go ahead and finish up this webinar and I'll log off of here. But I appreciate your time today and you guys logging on. I see a few of our clients on here today and it always makes my heart happy to see you guys on here. I wish I saw you guys more, but I know it's not always fun to come see us. It's usually some hard things have happened or some difficult things have happened, and just know that we feel right alongside you guys, and we cry right alongside you guys when we lose someone too. And if you need anything at all, we're here. And my email is cassidy.russell@mrclawcorp.com. And I appreciate your time today. I hope you guys have a wonderful rest of your afternoon. Take care.